Let's take a look at pre-employment inquiries from an employment law perspective. To avoid discrimination in hiring, it's essential that employers do not ask questions that reveal the protected class characteristics of job candidates. Questions on application forms, during interviews, or in the course of informal chatting with job candidates can end up divulging information about employees that may taint the hiring process. There are several things an employer should do. First, employers should not directly inquire about protected class characteristics. For example, an application form should not ask the applicant to check male or female or to indicate Mr. or Mrs. Similarly, asking candidates what their age is, where they were born, national origin, or whether they have a disability all constitute direct inquiries into protected class characteristics. Asking an interviewee about pregnancy constitutes direct inquiry about a protected class characteristic. This should not be asked prior to hiring because it can, consciously or not, affect employment decisions and result in disparate treatment. Employers that need to track the protected class characteristics of their applicants for affirmative action purposes can do so by providing a voluntary reporting mechanism that is completely separate from the application form or other materials used in hiring. Second, and slightly less obvious, employers should not indirectly inquire about the protected class characteristics of job candidates. Examples of indirect inquiries include asking for an applicant's date of graduation from high school, their age, or for a listing of all organizational memberships, which might indicate race, religion, or national origin. If the employer wants to know whether someone has graduated from high school, for example, that is what should be asked, rather than when the person graduated. Third, employers should avoid questions about requirements or criteria that are not uniformly applied to job candidates. Applying different selection criteria to different protected class groups is disparate treatment. Questions about marital status, child rearing plans, and child care agreements, and the answers to those questions are sometimes treated differently depending on whether the candidate is a man or a woman. Employers should avoid questions about requirements that have a high probability of producing disparate impact, such as arrest records or weight, which are likely to screen out some protected class groups more than others. Although it's a good idea to only ask questions about things that are job related, the law does not require it. The law requires employers to refrain from asking questions eliciting information that could be used to discriminate. Although the EEOC strongly discourages such pre-employment inquiries, most federal anti-discrimination laws, with the notable exception of the Americans with Disabilities Act, do not explicitly prohibit them. Many state anti-discrimination laws do not expressly prohibit such inquiries. In either case, asking questions about protected class has legal repercussions only when someone is denied an employment opportunity. Asking these questions makes a candidate suspicious of an employer's motives and more likely to challenge a rejection. They also provide evidence that the employer was aware of the candidate's protected class characteristics. Pre-employment inquiries constitute circumstantial evidence of discriminatory intent in disparate treatment cases.